Welcome, everyone. I'm really excited to have this conversation with you all today. I'm Rebecca Schaefer, and I'm the Legal Director of Fair Trials Americas, the Washington-based Office of Fair Trials, an international human rights organization focusing on criminal legal reform around the world. We have headquarters in London and Brussels, and a newer, smaller office in Washington, where we're trying to bring learning from Europe and around the world to support justice movements in the USA and Latin America. Specifically, we have a project called the Transatlantic Bridge, where we promote learning between North America and Europe. And the work we're doing on early access to counsel is part of that project. We have with us today a great panel of leading public defenders and activists in the public defense space, all of whom are working and thinking about the potential of extending the power balancing adversarial role of defense lawyers into police custody. To save time, I won't go deeply into their bios, but we have with us Amy Campanelli, maybe you can wave Amy, the Cook County Public Defender, which has, as far as I know, the only police station representation unit in any public defender office in the USA. We have Larry Redmond, an attorney with First Defense Legal Aid in Chicago, which is a community organization that has pioneered police station representation in that city, where police abuse and torture in custody has been rife. We have Premal Daria, who's founder and director of the Defender Impact Initiative, which works to maximize the strategic potential of public defenders. And finally, we have Randy Joya, the Deputy Chief Counsel for the Committee for Public Counsel Services, which is the public defender in Massachusetts. I'd like to start with a little bit of background about Fair Trials' entry point into this issue, which is really grounded in learning from being part of implementing access to counsel and police custody from Europe over the past 5 years. I'm going to turn to Fair Trials CEO Jago Russell, calling in from London, to introduce this work.
Thanks very much, Rebecca. I'm sorry I don't have some kind of backdrop of Big Ben or something to kind of illustrate where I'm dialing in from, but it's great to be part of this conversation. I'm going to keep my comments brief, because we have some great panelists, and I'm really looking forward to what they all have to say. Really, as Rebecca has explained, our objective in the United States is to try and accelerate criminal legal reform efforts by trying to offer a global viewpoint on some of the enormous challenges faced by the US reform movement. We know that offering a global viewpoint isn't going to provide any silver bullet solution to many of the huge problems there, but we think it can help. We think it can help challenge some deep-held preconceptions. So in this context, we think it can challenge deep-held preconceptions about the role of the lawyer and at what point the lawyer's role kicks in. But we think it can also suggest new approaches to tackling entrenched problems. So alternative big picture visions for the size and shape of the criminal legal system, but also practical policy solutions that can make a real radical difference. I just wanted to say a few words on why we were so keen at Fair Trials to be encouraging this conversation about station house counsel in the United States. Well, the first reason is that it's shocking to us that around the world, reforms have been taking place over the last decade and beyond to ensure that suspects in police custody have prompt access to a lawyer. It's shocking that while that's happening elsewhere in the world, and particularly in Europe, where Fair Trials is very actively involved, in the US, one of the richest countries in the world, arrested people are almost never able to access a lawyer until the first court hearing. That can be days after their arrest. So we're focusing on it because we're shocked by the state of play in the US on the timing of access to counsel, but also because we think it's hugely important. So let me just give you two brief reasons. So the first reason is that it's obvious that the hours or sometimes days that people spend in police custody, it's a time when arrested people are incredibly vulnerable to police coercion and abuse. And it's a time when they're closed away from the outside world, so there's no transparency or oversight of what's going on in police custody. So station house counsel, if we can help get lawyers into police precincts in the United States, it can act as a check on the terrifying power of the police, the terrifying power that they have over people that they're holding in police precinct. The second reason, though, is that we think that implementing station house counsel in the United States could have a kind of radical system-wide impact. because, you know, the US is a global leader in this kind of brutal machinery of criminal justice, which seems to kind of move, you know, straight to incarceration and long-term collateral consequences. We think at Fair Trials that if we can get lawyers involved much earlier in the process, they can disrupt that machine. Because by the time a person has gone to court, many of the key decisions about the case, like charge, whether to ask for detention, whether to dismiss the case or look for diversion, those decisions have been made. So if you can get lawyers involved much earlier, you can try and disrupt some of those decisions and have a huge impact on the overall shape of the system. A couple of words about Europe, which Rebecca mentioned. It's not that long ago where in Europe the situation was quite like the United States. You know, until quite recently in most of Europe, people that were arrested didn't have access to a lawyer until the first court hearing. They certainly didn't have access to a lawyer if they weren't rich enough to pay for one, and if they didn't have the contact details of a lawyer to hand. The exciting thing in Europe, though, is that that's changed, that the battles for change on access to a lawyer have really been working in Europe. And so now across Europe, all arrested people have a right to consult a lawyer shortly after their arrest. They have a right to a lawyer during police interrogation. They have a right to free legal representation in many cases, and certainly when they can't afford to pay for a lawyer. The police are also, they're required to help arrested people get access to a lawyer. States have been putting systems in place to make sure that lawyers are notified and arrive promptly at police precinct. And if a person is denied access to a lawyer, isn't provided with help in accessing a lawyer, or is deterred by the police from exercising their right to counsel in police precinct, well, any evidence or confession that's given to the police is just not admissible in criminal proceedings. And we think that Europe's experience in recent years of implementing this huge change could offer a huge amount of insight and learning into how these kinds of reforms could happen in the United States. And, you know, it feels like an important time in the States to be having these discussions, because even 18 months ago, when Rebecca and I at Fair Trials were speaking to people in the US about this idea, the view was, oh, you know, that's an uphill battle. You know, that's going to be incredibly difficult to achieve. But it feels like the balance of power between police and over-policed communities is really shifting now in the United States, about time, and that's creating opportunities for reforms like this to become realistic and workable. And, you know, we've all seen the horrendous bystander videos of police violence of citizens on the street. And through this conversation and through this area of reform, we really think we now need to start shining a light on what's happening in incommunicado detention in police precincts. And the aim of this conversation for us is to kickstart that conversation, to see if we can help make a case in the United States for getting lawyers into police precincts. And if we can try and help people on this call and others that are joining the webinar to figure out models for making this work in their own jurisdictions. I'm really excited to hear what the great panelists have to say. So I will stop now, but thanks everyone for joining this webinar. Thank you.
Thanks, Jago. So I just wanted to start with a sort of picture into what the context is now. What do lawyers have in relation to access to arrested people in those early hours in police custody? I want to go to Pramal first, because you have a sort of national overview about what it looks like in different cities with different public defender offices, and then I'll move into the particular cities.
Sure, thank you. And thank you, Fair Trials, so much for hosting this conversation. I'm really excited about it and excited to get the international perspective as well, which we, I think, desperately need in the United States. So the way that our court system is structured is really grounded in counsel sort of activating or attaching at the first judicial proceeding. And so what that means is that entire systems, court systems, the system of indigent defense in this country, everything is kind of built around public defenders or lawyers, you know, starting to represent people when court starts, when they make their first appearance in court. And so that's really the starting point of the assistance of counsel piece of the process. And before that, it's a very lonely time for people who are arrested in terms of you know, their detachment from the community that they were arrested in, and also the access to the counsel that can help them navigate the system. So there's this sort of black hole, right, that happens in between arrest and when you get to meet a lawyer and you're in court. And I think that the uprisings of the last few months have made crystal clear that we are long overdue for a critical analysis of what's happening during that period and why we haven't really rethought, counsel being available much earlier.
Thanks, Premal. Randy, can you tell us what it looks like in Boston? What happens when someone gets arrested? How soon can you access them? And are you ever in police stations with them?
Yeah, it really is a black hole, as Premal says, Rebecca. And from my perspective, the only access you really have to people in custody is when someone in custody calls a lawyer and asks for them to come to the police station. And what I know is that that really only happens with wealthy, well-educated people who know how to access counsel when their sons and daughters are arrested, but it disproportionately affects Black and brown people in communities who don't have that ability to access counsel. And so in that period of time, what's going on in the police station? Well, one thing we know for sure is going on is that many uncounseled waivers of rights are being signed. 80%, I've seen 80% of people in custody agree to submit to a police interrogation without counsel. And what the police produce when they have to produce it is a signed piece of paper, not signed after advice of counsel, but signed after the police basically go through this just rote recitation of the Miranda warnings. Miranda is really, it's an empty case right now. It's not working. We need something more than Miranda. What Miranda has led to is just many, many uncounseled waivers, many coercive interrogations. And even if a person invokes their right to counsel, the police can continue to question that person. They don't have to get a lawyer for a person. And even if they can't use that statement during their case in chief, if the prosecution can't use it, they can still use it. Even after a person's invoked counsel and the police don't provide it, if the person testifies to impeach the person's incredibility. So this is a real critical point. I totally agree with Jago. This is an opportunity to get lawyers into police stations, get them to our clients at the earliest possible time to stop these coercive police interrogations. And there's so many other things you can do when you get into a police station for a client at the very beginning. The process, attorney-client process, has to start at the very beginning. Wealthy people, rich people, well-educated people know that and can access lawyers because they can pay for them. This needs to happen for poor people in underserved communities also.
Randy, I just wanted to ask you, thanks for that. Like, what if you had a really sophisticated or well-educated family who had a family member arrested and they know to call the public defender? They called you and they said, my son is arrested, he's in this precinct, can you go? What would happen? Could you do that? And what if not, why not? What's blocking you?
Well, we would certainly try to do that for sure. I mean, one thing that, are the police going to let us into the police station? That's also a problem. We could be there and demand to see our client, but they don't really have to let you into the police station. And from our perspective, I mean, for sure, we can only represent people who are unable to afford counsel. But if somebody calls up and they tell us, look, my son's arrested, he's in the police station, we will try to get a lawyer. We do have a system in Massachusetts where we can assign lawyers to clients pre-arraignment, and that kicks in, but that doesn't happen very often at all, Rebecca. That's a rare event when we get those kinds of calls. But we still have impediments to get to see our client and to get to talk to our client and to stop the kinds of things that need to be stopped when there's a lawyer who's allowed into the conversation and allowed to have a meaningful conversation with their client.
So it sounds like there's potentially some administrative changes that need to happen with appointment of counsel and how that happens in order to improve things, but also just public education and change in police cultures. I want to move to Larry, because I know First Defense Legal Aid has been doing the work of getting into police custody for decades, I believe. And there are particular issues with the Illinois statutes that have put it to the forefront, and also with the behavior of Chicago police, specifically during the period of custody, that have really made this issue more prominent in Chicago than anywhere else. And also the work of First Defense Legal Aid has been critical in developing, I think, the most advanced police station representation that we have anywhere in the country. So could you tell us what it's looked like sort of historically, briefly, and what your work looks like now in police custody?
Sure, I can help you with that. First Defense Legal Aid has been around for about 25 years, and I have been affiliated with them for like the last 5 years or so. Although I did take some cases with them as long as 15 years ago. But back then and today, the challenge was essentially the same. The police do not want lawyers in police stations because they understand the power of a lawyer to prevent them from railroading a person into a situation where they will spend the rest of their life in prison or have to deal with having been arrested and convicted of a crime that maybe they did not commit. Over the years, we have worked assiduously to, and especially in recent years, to not only make counsel available for individuals who have been arrested, but to apprise the public of the fact that we are available. Because part of the problem that we are finding and have found is that the public doesn't know that they have the right to counsel when they have been arrested. And we have found in a lot of cases that people don't understand the criminal justice system. And that's a big problem. They think that all they have to do is go into a police station and explain to the police what really happened. And the police will say, oh, I understand now, you may go. That is not the case. And we have to let them know anything you say will be used to try to get you into prison. That is the police's, that's the police department, their job is to put you in prison. And everything they do is geared towards that. And unless you understand that you have to fight back from the very outset, you are in a losing position. And to address a little bit about the question that was asked earlier on to Randy, my experience has been, if you go to a police station, they will tell you, they might give you a hard time seeing your client, but as long as you are in the police station, you might yourself have to become a witness. And so you might be precluded from taking the case because you might have to be a witness to say, I was at the police station at 1 a.m. in the morning, and I waited there for 6 hours. And during that time, they did not allow me to see my client. And therefore, anything that happened during that time cannot be used in any way, shape, form, or fashion because I was there and you did not allow me to see him. And so, First Defense has done a lot of things over the years, primarily in station house visits, but also in education of the public.
That's great. Amy, can you talk to all of us about what Cook County Public Defenders are doing in police custody now, your police custody representation unit, and what that practice looks like?
Of course. Again, thank you, Fair Trials, for having me for this panel. So working off what First Defense Legal Aid has been doing for 25 years, like Larry just said, when I became the public defender in 2015, shortly after that, Laquan McDonald was killed. And he was shot 16 times by Jason Van Dyke, a Chicago police officer. And we were already having discussions, unbeknownst to me. There were discussions between private counsel, advocates, First Defense Legal Aid, and our chief judge here in Cook County. Remember, I represent all the citizens of Cook County who cannot afford to hire an attorney. And that includes, Chicago and all the suburbs. And what they were talking to the chief judge was about after Laquan McDowell, which became even more immediate, that we need to have lawyers at police stations, that it's too late, like what everybody's just been talking about here, what Pramal talked about, it's too late to stop injustices by the time someone comes to court. At the police station, at that intercept, if someone has a lawyer, we can stop abuse. We can inform people of their rights. We can bring trust to this system that nobody trusts. So Chief Judge Evans signed an order, a general administrative order, appointing me and my office at police stations, right? For anyone, rich or poor, old, young, black, white, brown, anyone who's arrested. You don't have to be indigent for a public defender to go to a police station and represent someone if we get the call, right? I got to get the call. So at March of 2017, Chief Judge Evans issued that order. By 2018, I built a unit of 9 lawyers to be ready, willing, and able 24 hours a day, 7 days a week, every day of the year to go to police stations when we get the call to represent clients who are in custody all over Cook County, not just Chicago. And we've been doing that work, and we've been very successful at representing clients when we get the call. But the education piece that Larry talked about, and us, we're building on that education piece to let people know that you have this right to counsel, that you should never go and expect to be at a police station and expect to represent yourself. You can't do it. You're no match for law enforcement who have years and years of experience and have all the control, right? And just like what Jago said, there's no transparency. We've never been in police stations. So I had to train my lawyers. We had to work with First Defense to have this declaration of rights. And now that we're in these police stations and we go to these police stations, we see the other abuses that have occurred for decades. We see the other violations of the law that police have not done. They haven't been giving our clients phone calls. We already knew that. We knew that. But now we're actually able to talk to the clients at the station when we get there and say, did you ask to use the phone, or did they give you a phone call? Because you don't have to ask for a phone call. The law requires police in Illinois to provide a reasonable number of phone calls within a reasonable time of arrival at the first place of custody. But they never do that, right? They don't give you a phone call, so you can't get access to a counsel. You can't get a lawyer. You can't call your mother to get you a lawyer. So we have found that since we've been going to police stations for the last over 2 years now, that not only do we protect people's rights, we inform clients of their rights, we bring trust to the system, because when someone feels like they've been treated fairly at a police station, they tell their family about that. They trust the entire criminal system. They trust their public defenders. It brings trust to my office. But at the same time, we walk out uncharged at about 18% of the people we see. So we save those people. We save millions of dollars from people coming into a system and being wrongfully charged, wrongfully pleading guilty just to get out of jail because they couldn't afford their bond, wrongfully sent to prison when they never should have been arrested in the first place.
That's amazing. I wonder if anybody else could weigh in on what the sort of, what could you do if you get into police custody? Randy, your lawyers aren't going into police custody now. What could they do if they got in there?
There's many things they can do, Rebecca. I mean, for one, probably primarily is we could try to end uncounseled waivers and coercive questioning. But aside from that, and that's really important, obviously, we could advocate for diversion from the criminal justice system, especially important for first-time offenders. Before the case gets to court, before a complaint is issued, there's a time and an opportunity to advocate for diversion from the criminal justice system. In Massachusetts, often lawyers can advocate when they go to court for dismissal of the case prior to arraignment. And if that happens, what that means is the record of the arrest never appears in a centralized criminal offender record information database. That's also very important, but usually that can only happen when a lawyer is hired before the case goes to court. if counsel was allowed into the police station, they can begin that advocacy at that particular time. And that's important. And of course, they can begin to negotiate the terms of release, get in touch with people, family members, other members, try to get together some kind of a package to argue to the prosecutor and ultimately to the judge that this person should be released. And I think what will happen eventually, if you have this, it will dispel the notion in this country that there are two systems of justice in the United States, one for the rich and guilty and one for the poor and innocent. That's something that Brian Stevenson has said, and it's very true. And that's what we're trying to, that's what I think, if we can do something like this, if we could bring the Sixth Amendment into the police station, we might be able to begin to dispel that notion.
Yeah.
Rebecca,
Larry,
can you guys hear me?
Yeah, I can hear you. Yeah, Larry, were you trying to say something? I was just going to turn to you, and because I know you've spent a lot of time in police custody, and you've said something to me before, which is about how the police change their behavior based on just your presence there. I wondered if you could speak to the sort of larger cultural shifts that could happen with having outside folks in these closed spaces.
I'd be happy to. When I have represented people in police stations for a number of years, and usually the graveyard shift from midnight to 8 in the morning. And what I have found is that, well, the first thing I tell my client when I see him in the room is, do not talk about your case. Do not say anything about what happened in your case in this incident. And the reason is because very often the space that we are in is not private. The police will tell you, yes, this is a private space just for lawyers and your client, but they will stand outside the door with their ear to the door to listen to see what is being said. And so I always advise them, don't talk about your case during this conversation. The second thing I tell them is, after I leave, do not talk to the police at all. Any question they ask you, your only answer is, I will not answer any questions without the presence of my lawyer. And I tell them, it doesn't matter what the question they ask you is. If they ask you, do you like ice cream? You answer with that same answer, because you don't know why they ask you if you like ice cream. Unbeknownst to you, right around the corner from your house, the local local ice cream parlor was robbed and somebody got killed. And so they're trying to link you to that incident. So do not answer any questions. After that, I will ask them things like, how have they treated you? Do you need medication? Do you need food? Have they fed you? Have you been to the bathroom? And you'd be surprised how often I get negative responses to those questions. There were a couple of incidents where I was very successful in getting my client out of custody just because I walked in the door. And sometime once a lieutenant came to me and said, yes, we're going to release him because you are here. He said that in plain English. And when I found out, when I talked to my client after getting him out of the station, what he told me was this: when he got arrested, they were very abusive. They were casting racial epithets. They were threatening to beat him. They were giving him all. He was terrified of the behavior of the police while he was in custody. When they learned that I had arrived, their entire demeanor had changed. They called him Mr. So-and-so. Your attorney has arrived. They tried to clean up all the mess that they had created before I had arrived. And when I left with him in hand, he thanked me profusely. And that's the kind of impact that an attorney can have at the police station. Now, not all of these turn out so well. In one incident in particular, I was in Markham, which is a suburb of Chicago, and they had my client there. They told him he was a witness, and they were just investigating him because they wanted information about the the incident that had occurred. And they told him he was not a suspect. I came in, told the police officers, you're lying, he is a suspect, and you're trying to trick him by telling him that he's only a witness. I walked out with him, and what happened was, ultimately, he got a lawyer that did not know how to deal with in-station, just how to deal with an in-station event. And the lawyer that he hired allowed him to talk, and they ended up putting him in prison. And he's in prison to this day. And so not only do you have to have counsel in the police station, but you have to have counsel that knows what they're doing in the police station. Because sometimes a lawyer will want their client to talk. And that can be problematic. It can be harmful. And so, like I said, I always advise them to not talk.
Yeah, so we've heard some really powerful testimony today, and I just want to encourage everybody who's watching that you can ask further questions in the Q&A, and we'll get to them at the end. So we've heard about the way that lawyers in police custody can act as decarcerative agents. They can get cases dropped, diverted, just try to slow the roll of cases through the system, the way they can act as checks on police misconduct, abuse of arrested people in custody. I'm also wondering, and Pramal, maybe you can speak to this and a couple of other issues, whether there's a role for lawyers in custody to be gathering information about how police are acting in a more systematic way, whether there's a role for them in oversight in that way. And then I also would like you to speak to how lawyers in police custody could interact with other movement actors, community organizations, so that they're more than just about particular cases, but really about changing these spaces of incommunicado detention into more democratic places where community has oversight and ownership.
Yeah, thank you. I think we've been talking a lot about the ways in which having police stations be open to counsel would, result in sort of more counseling, less waivers, and those sorts of things. And I think those pieces are really important, right? Like those procedural moments in the process are, of course, important. And I think that's certainly true that having counsel there would help. In terms of, in my work, I'm really interested in the kinds of changes to process and procedure that can be transformative and not necessarily just sort of reinforce the process or the system, right? But really cast a light on how to shrink it and how to stop the machinery of violence that our criminal system perpetrates. And I think that this kind of intervention can really do that as well. I think it can serve a number of different goals. And so with respect to, the ways that lawyers being available at the police station can help in sort of like bigger picture ways. I think what you mentioned about oversight is a really critical piece. Just having people there who see what's happening. How are the police engaging with people they've arrested? How are they physically treating them? How, what's happening in there? I mean, frankly, so many of us just have no idea what's happening in American police stations. It's all very secretive. It's all, we don't have access, communities don't have access, and lawyers don't have access. And so getting that access, I think, is just critical to being able to engage communities and the public to be able to make informed decisions about how to change our systems, right? How do we even do that without knowing what's happening behind these closed doors? And so I think that's a critical piece. I also think that there are big ways in which this kind of intervention can have impacts. For example, in addition to slowing the number of uncounseled waivers, it can dramatically change bail decisions, charging decisions. These are sort of trickle down effects that can stop the machinery of mass incarceration, right? Like it can, having public defenders present in police stations can change the course of evidence in cases, which can change how plea offers are made and the level of coercion that's utilized throughout the criminal process. And so I think that there are all these different facets in which just sort of one intervention like this can play out. It could also potentially change the way arrests are made, right? Maybe less arrests get made because the police know that there are going to be lawyers at the front door saying, what happened? Why did you do this? So I think on the front end, on the back end, all throughout the process, this can really be transformative and can put a stop to the machine that's rolling. Another piece of this, as you mentioned, Rebecca, that Defender Impact Initiative is particularly interested in, because our work is really about figuring out ways to tie the work of public defenders very directly to the communities they serve, right? Figuring out how can lawyers be supportive of communities and social movements in the most productive way. And I think that this kind of intervention is a tremendous opportunity for community engagement, to build power in communities, for lawyers to, of course, potentially be the tool in the police station, right? We're the part of the system that can engage in that way with people who are arrested and with other system actors, but for that to be on behalf of the communities from which people came who are arrested, right? For lawyers to be able to help empower those communities to have, you know, a voice and control in how people are policed, in you know what that looks like, in whether or not they're policed, and in shrinking that system so that it, you know, so that people can actually feel safe and in control of their own communities. So I think that this is a very powerful avenue for that kind of community engagement. I also think that in the space of, you know, criminal system change and reform, we have to be thoughtful about what kind of change is going to be sustainable, right? And ultimately, it's change that comes from communities that's going to be sustained and it's going to last well beyond the lawyers that cycle through courthouses and that sort of thing, right? And so when we see all of the community-driven movements that are happening around the country right now, you know, there's so much power in community bail funds and in participatory defense movements. And when we think about those kinds of changes, which will be sustained because the power they have is from the communities themselves, I think that that's a really powerful model and way of thinking about how this kind of intervention could be tied to communities. And so that's what we're, you know, my organization is particularly interested in exploring that with community organizations and how this can lead to the community having a greater voice in how their communities are policed.
That's super powerful, Premal. Thank you for sharing. Yeah, and I did want to sort of dig into some of those themes a little more with you all. Sometimes when I talk about access to counsel with folks, I get pushback from a lot of different angles, depending on who I'm talking to. But one of the questions is like, does this move us in a liberatory direction, or is it just a sort of technical fix? It feels procedural. It's just giving power to lawyers. Is this really transformative? How does it dovetail with more radical demands to really shrink the size of and power of police and the criminal legal system in general? And Premal's touched on some of this. I wondered if anybody else had anything to add on that.
I'd like to add a little.
Oh, go ahead.
I'd like to add a little something, if I may. Police culture in Chicago and probably throughout the country and maybe the world, they run fast and loose with protocol and procedures. They see these movies about police officers who are heroes because they break the law, because they bend the rules, and all of them want to be that person. And what we have found at First Defense, we would keep records of all of the station visits that we made, and we were able to document patterns in how police officers throughout the city perform their job. And we were able to take this information to the police department and tell them, did you know this is what is happening in your police stations? And sometimes we get answers like, well, in fact, they did know it because they are police officers and they've been in the stations themselves. But if we can document to them that this is what is happening in the police stations, it puts them in a position where they have to at least give lip service to trying to change it. Now, the Chicago Police Department, they push back on any kind of reform that is proposed. The consent decree had made like 195 recommendations for changes in the police department, and they have pushed back on all except 5 of them. So it is what they do. But once we establish that this is the way it ought to be, it becomes a lot more difficult for them to push back. And it also gives individuals and organizations who are in a position to promote reform more ammunition to get the reforms that they're advocating for in place. So that is the kind of thing that keeping records can do.
Super helpful. It seems like it moves from a sort of, yeah, you're so far downstream as a public defender in these cases, collecting anecdata. It really gives you, it empowers you with a lot more data to look at the whole system and start to fight back a little bit. Amy, what did you want to add?
I was just going to say the same thing, Larry. We have been documenting every single visit that we've gone on since we started the work back in March of 2017. Mm-hmm. And this data has really informed what in fact is happening at police stations, which quite frankly, we already knew, but we didn't know the scale. We didn't know, every police department isn't the same. Even within the Chicago Police Department, we have information now that certain districts behave a way, whereas other districts don't behave the same way. So with that information, that drives not only what I'm doing going forward, which is I'm putting some legislation down in Springfield. I'm actually currently suing the Chicago Police Department. I'm not going to talk about that, but it informs and gives me data and facts to support my positions. But what
Amy's
was talking,
view has just frozen up on my set.
We can still hear her. It's okay, Larry.
Okay. So what Pramal talked about with the community, right? What we've seen by going into the community, we go to the schools, we tell young people, if you get arrested, you need to call this phone number. Do not get your mother to call if they take your phone. These are your rights. You should not be at a police station alone without an advocate representing you. And just from that community outreach, we have built up more power for not only people to call us in their individual situations, but for more community advocacy to come forward. And I'll just give you one example, the protests, right? We had 300 protesters arrested, over a weekend or 2 days. And the media attention that came from the protesters who then spoke out and said, I asked for a lawyer and they didn't give me a lawyer. They didn't give me phone calls. They hid me in a lockup for hours and I wasn't able to talk to anyone, even though I kept asking. So the fact that these innocent people, right, who were just out protesting, and many of them were arrested and let go without any charges, the majority of them. So these are, quite frankly, the general public, right? Their voices were amplified here in Chicago to then bring that community movement of, we need to make change in our police reform. How can we allow police to do this to people who were just lawfully protesting, and then they were held incommunicado and their rights were violated? So these events that happen, whether it was Laquan McDonald, George Floyd, protests, are amplifying this need, hopefully, to all of the United States and all public defender offices, that they need to try and get in to the station to do this work, because reform is coming here. It is, and it's working, and it's proven by my data, which then I can use, like I said, to change legislation, get the Chicago police to do what they're supposed to do, which has been the law since 1963, pre-Miranda, right? All these things that we can hold people accountable for and make change.
Yeah, that's really speaking to the kind of conversation that I hoped we would have today, which is about the way that bringing counsel into police custody isn't just about individual cases, but is about equipping the public with power and making the police understand that they answer to the law, that there's a law that pertains to them, and that law can be enforced by individuals with the assistance of lawyers, and that there really should be a major shift in power there. I want to shift gears a little bit. There's a couple of questions on this front, unless Randy, you wanted to get a word in on that.
Well, I just wanted to say, Rebecca, these police stations are in the communities. They belong to the people, and we really need to shine a light inside the police station. The cops don't want lawyers in the police stations. And it's obvious why they don't. And the reason they give is that they say it's going to interfere with crime control. In other words, if we don't have the chance to question people and to get confessions, this is going to lead to an increase in crime. It's absurd. And the famous case, the Escobedo case, which was a Sixth Amendment right to counsel case, Justice Goldberg wrote the opinion in that case, and he said, if the exercise of constitutional rights will thwart the effectiveness of the system of law enforcement, then there's something very wrong with that system. So for the police to insist that having lawyers inside police stations will affect crime or increase crime is just absurd, and there's something very wrong with the system. And
I think, and that's where some of the comparative, I think, experience can be demonstrative as well. Like if you look at England and Wales, which has had lawyers in police custody, I think the longest since the 80s, they do have a homicide clearance rate that's enviable. Globally, it's over 90%, has been for many years, and they have lawyers in every single interrogation waived, not nearly as often as the right is here. Police are accustomed to dealing with defense counsel in custody suites every single day as part of their interrogations, and they are very able to solve serious crimes. So it hasn't impeded their ability to operate at all. And as a result, they enjoy like a 78, close to 80% support from the public. British police do, which allows them to conduct effective investigations with cooperation from the community. So I think we can look at data from Chicago and from around the world of places that allow counsel into police custody. I do want to shift a little bit because there's a bunch of questions about sort of like the practicalities of setting up a system like this. And I think Amy, you can speak to this a little bit from implementing a new system, and Jago, perhaps you could also talk about different models in Europe. But who sort of needs to be at the table? Who are the decision makers, and who are the necessary people that we need to engage with to set up a system like this? And there are a number of questions about funding. So Amy, maybe you could speak to that as well, whether it's been costly on you, who bears the cost, how costly it's been, and what's the most efficient method of providing counsel in the, I think, 120 police stations that you cover?
Right, we have over 100 suburban police stations and 22 police districts in Chicago. So obviously at the table for me, in order to have the authority to go into a police station, I needed a court order. But you would need to look at your public defender statute, your public defender act, and how you are appointed in cases. Because like Randy said at the beginning, he can't just go to a police station. He can't just send his lawyers to a police station because he has to have the authority to do that. There's a statute that gives him the duties that he does as a public defender in Massachusetts. So I got the chief judge of Cook County to give me the authority in Cook County to go to police stations and represent anyone who requests counsel. Now, other public defenders in the state of Illinois do not have that right. They do not go to police stations. They would need that authority either to get that from their Cook County, whoever is their funding source, quite frankly, whoever sets their budget. Usually it's the judiciary in most of the other counties in Illinois. But so I had support from advocates, from private attorneys, from First Defense Legal Aid, and from the judiciary, and it was a good time, right? Like Jago said at the beginning, the time is right. So every public defender system will have to look at their system and say, how do I get into the police station? What legal authority do I have to do that? And then what resources do I need? And I started small. I made sort of every lawyer in my office sort of take a shift at the beginning. And then we formed a unit, right? That took us a year. It took us 1 year to form a unit of 9 lawyers to be on this shift work. Now, we already knew, looking at our prosecutors, and you could look at your prosecutors who do go to police stations at all hours of the night, right? They interview our clients at 4 in the morning or whenever. So they have these shift work. You can work on a shift schedule. And quite frankly, lawyers like to do shift work, 3 days on, 4 days off. But you do have to get some funding for a few more lawyers to start. But quite frankly, it's not all that expensive, right? It's a new unit. You start small, and they're on call, and then you have supervision. And we used, quite frankly, the supervisors I already have. I just added to their workload a little bit. But so it's the legal authority to do it, and then the resources to do it, and you can be creative. And I know, talking to Rebecca and looking at your your fair trials document that you wrote, that wouldn't it be great if we had public defenders stationed at police stations? That's going to take another lift. I think that's a great idea that a public defender would be stationed at least maybe during one certain period, 7 a.m. to 3 p.m. or midnight to 7 a.m. And anybody who's arrested, we would need the cooperation of law enforcement though, right? I don't need the cooperation of law enforcement right now to show up and demand to see my client. So you're going to have to get the cooperation of law enforcement if you actually want a public defender to be stationed at a police station, which is under their control. So that would be a bigger lift, but you could do that. We just have to get them to the table.
Right, and we have a question about whether, I mean, most of these efforts have been, well, countywide in your case, Amy, or we're working with particular cities, public defenders in particular cities. And there's a question about whether it's possible to make change on a state level or in a broader way. What would that look like? Can you imagine a broader base?
I'll just say one quick thing, and then maybe some of you want to talk about this. On a state level, we have 120 counties in Illinois. I have some rural public defender offices where you have one public defender who's doing the work for 3 counties. And then we have bigger cities here that I have bigger offices like myself, DuPage, Rockford. But, it's the will, it takes the will of the public defender, who's the leader, right? Who wants to do the work and is going to fight with their funding source, their judiciary, who sort of controls the work you do, and the statute, right? The law, what governs your duties. You have to make a change there because right now, the Illinois statute says that public defenders are appointed at court, right? So you have to go outside that realm and say, no, public defenders can be appointed as if they're in court at a police station. So you have to have the will of the public defender who's leading that office, and then that public defender has to start the conversation with everybody who's going to be affected by this. And I'll just say one last thing. After I got the right to do this work, I tried to go to every single police department. I talked to Chicago police, of course, in a group, but I went to every suburban chiefs of police. I still have like 70 suburban chiefs of police to meet with one-on-one and tell them that I'm doing this work. I bring posters and say, this is the law. You have to put these posters up. And by the way, would you put my phone number up? Would you put my phone number next to the poster and make sure you're giving my clients phones, because that's been the law since 1963. I'm not saying you're violating the law, but if you are, you better start doing it now. So you meet with them one-on-one. You tell them what you're doing. I was so nervous. I don't usually meet with chiefs of police, but I went to their meetings. They meet together, right? There's the North Law Enforcement Agency, the middle of the state, south of the state. I met with them. I met with them in Chicago and the suburbs to say, look, I'm doing this work. You can't keep me out. This is the law. So here's what I expect you to do, and why it's important to bring trust to your community. I try to, and of course, some of the police officers did not want to talk to me, but they listened, and you could tell they were, gee, I'm talking to a public defender. I've never talked to a public defender before. But, that's the space we have to go into. It's uncomfortable. It's new. It's frustrating. But that's as public defenders what we have to do. We have to push ahead. We have to push the envelope. That's why we're public defenders. That's our whole mission.
And I think, Amy, I think you're absolutely right. You have to start small. That's the only way to do it in the United States. And then we have to show, when we start small, what is the value to the community of having lawyers in the police stations, of opening up these police stations. What is the value? What do they bring? How does it improve public safety? How does it encourage fairness in the criminal justice system? So I'm curious, have you thought about, or do you have ways of measuring the success of your program that you can then bring to the community and to funders and say, hey, look, we started this program, we have lawyers going into police stations, and this is why it's been successful, and this is why we should expand it?
Well, for me, I'll just answer that. I told you we're walking out 18% of the people that we see at a police station uncharged. So the cost savings there, we can round up. And this is just with us visiting 2% of the people who are arrested in Cook County. 2%. It was under one, it was about 0.5% when I started in 2015. First Defense Legal Aid was visiting about 0.5% of the people arrested in Cook County. Now we're at 2%. We've jumped 1.5%. And of those 2%, I'm walking out 18% of the people uncharged. Imagine if we represented 10% of the people arrested. You have to think big. How much money would I be saving Cook County by not only diverting people, getting people charged correctly, which then doesn't stem into wrongful convictions and reversals, right, in the future, like Pramal was talking about, but quite frankly, walking out people completely uncharged. And we follow through with those clients. We try to make sure that we, if they need to get into school or they need a job, we try to link those clients. We don't say, oh, you're done, we're done with you. We follow up. So there's this holistic defense of everybody we meet, and that affects their family, their communities. If I can get that client who wrongfully arrested, goes home but needs services of some sort on the right path, I'm then saving that person from future arrest, making future bad decisions. So it is about cost savings if we could up to 10%, and also about, you know, doing the right thing here, right? And getting our communities safer by getting people who find themselves in these situations.
Rebecca, could I chime in
right?
a little bit on
Yeah, go ahead.
Go ahead, Larry. Yeah. Is there something you wanted to say? I actually wanted to hear from you, because as a community organization that managed to get access and build a police station representation program without a court order, what did that look like? And what recommendations do you have? And Pramal, I thought you could come in on this too, for making sure that if we get access for lawyers in police custody, it is in this way that's linked with community building, so that it doesn't just become a technical fix that doesn't have the sustainability we're looking for.
I think Amy was raising the issue of funding. What that really comes to is political will. And this becomes a much bigger problem when you start talking about political will, because a lot of the judges in Cook County, and I'm sure that Amy can back me up on this, they're former prosecutors. And former prosecutors are the ones that work with police in order to accelerate the prison, you know, pipeline, the school to prison pipeline. And so when we talk about success in this area of public defenders getting people released without charges, there's a lot of forces in this city, in this county, in this state that don't see that as success. They want to see that kind of movement stopped. They want to promote more people being incarcerated. The FOP is very powerful when it comes to funding individuals that are pro-police, pro-law and order, pro-school to prison pipeline. And so it's not just public defenders that have to get involved in this. In Chicago, we have a movement to try to stop the power of the FOP, to stop the power of these judges, because we're challenging some of the judges that are making bad decisions on the bench. We're challenging their right to be retained as judges. So it's a much bigger problem than just what we see in public defenders' offices and in station visits. It's a culture that wants to send people to prison, and that whole culture has to be challenged and stopped in some way. And the movement that people have been alluding to, people in the street, we got an ordinance we're fighting for an ordinance called CPAC to gain community control of the police, specifically to reverse the kinds of things that the police are doing. And the city council it's very difficult for the city council to get on board with this, because many of them have been financed in their campaigns by the FOP. And so it's a very big political issue that we're talking about here that we have to deal with.
Kamal?
Yeah, thank you. Yeah, this is so educational and informative, and I really appreciate this conversation. So thanks again for hosting it. I was reflecting a little bit on some of the pieces of the conversation, and I think one of the things that's occurred to me is that in thinking about how these kinds of interventions can be led and developed and created, I actually think that lawyers aren't the leaders, right? I actually think that it's the communities that can and should be leading these kinds of interventions. You know, the community has spoken and is speaking throughout our country very clearly about its opinion of the police in the United States and how the police conducts itself. And I think that as public defenders, lawyers in general, but certainly public defenders, the most useful role that we or they can play is to liaise between the community and the system, right? Public defenders are not necessarily in those communities that are over-policed, that are directly impacted, that are feeling the violence of policing in America. And so, but they are experts in how the system operates in many ways, right? And so they can liaise and be a tool or a resource for communities to access what they need to access to make the change that they want and need. And so I just wanted to sort of frame that in the way that I'd been thinking about it, which is really to be a community-driven movement. And so not so much about educating the community, right, but listening to them and saying, what is it that we can do? So that's the framing I think is important. And partly it's important because we want to be careful not to fall into traps. There's so many, reforms, to use a loaded word, that can be limiting, or that can cast a veneer of change when there isn't really change, or that can reinforce the status quo, right? And in this moment of great clarity in the United States around the violence of our criminal system and policing, I think it's really, extra important to be careful about how we try to make changes, and to be careful that what we're doing doesn't reinforce some of the very problematic power structures that already exist, including in police stations, but shrinks it, undermines it, challenges it. And I think that this intervention in particular, having communities drive access to lawyers in police stations, could be a transformative intervention for that bigger movement of addressing mass incarceration, of stopping that machinery of violence, but that we need to be careful in how we're thinking about it and framing it for it to get there, if that makes sense.
Yeah, I think it's really instructive, the story of how police station access happened in Chicago, because it did come out of community activism and community organizing. And you can really see the mark of that in your ongoing litigation around the sort of arbitrary detention of protesters. Recently, if you look at all of the co-plaintiffs, it's like a million different grassroots community organizations working in tandem with Cook County Public Defender. And so I do think that that's a super interesting model for us, and really instructive. I also wanted to give Jago a chance to ask any questions if you had some. I have some more from participants, but you've been listening and taking notes, and I'm wondering if you have any questions.
I very much see it as my role on this to kind of listen and take notes. There's been so much kind of interesting input. I'm also seeing a huge chain of questions coming in. You mentioned earlier on there, Rebecca, there's this question about kind of models in Europe and how the learning from those might be useful. I think there's a bunch of different learnings in terms of how you might implement this, how you might overcome things like, the very creative ways that many police try and get around whatever the rules say on the requirement to make contacts with lawyers. So there's loads of kind of learning there. One thing I'd say though, on a positive note, is that in a way you have a real kind of advantage in the US, because in Europe this battle was happening in the context of almost entirely private appointed lawyers. So indigent defense in Europe is provided by contracted private lawyers. So this need for public defender willingness and the ability to kind of coordinate public defenders offices to provide this service and this liaison with the community just didn't exist. So to be honest, that has been and continues to be the single biggest battle in Europe, is building lawyer willingness to engage in effective public defense in police precincts. And as I say, like, without wishing to suggest that this is an easy challenge in any way, I think there's a real advantage that many jurisdictions in the US have because of the public defender model. And just listening to you guys speak today is really exciting in terms of the desire of driven public defenders officers to try to push the envelope on this issue. But I'll leave it at there because there's two more questions since I've started speaking.
I mute myself and I unshowed myself. So there's a question about whether there actually is a right to a lawyer upon arrest. Like, what is the Miranda right? And I think it speaks to a larger question of like how we frame this right, how we talk about the right to access a lawyer in police custody as a matter of politics and a matter of policy, whether you have to make that precise a legal argument as you would before court, or whether this is bigger than the narrow way in which the right to counsel has been construed by courts. Anybody have anything to say about that?
I can give an opinion on that. I think Miranda is pretty clear. Anytime there is a criminal, anytime an individual is facing a criminal prosecution, he has a right to an attorney. And my feeling is that it begins at the police station. Some folks will argue perhaps against that the police ought to have that 48 hours to interrogate you before you actually have an attorney. But I think that's madness. I haven't read Miranda in a number of years, to tell you the truth. But if there is anything concerning a criminal conviction that you're facing, you are entitled to a lawyer. And that's what Miranda says. That's what it says. And the fact that you typically don't get it until you get arraigned or there's a bond hearing or something of that sort, that's madness. You deserve an attorney. The minute an officer puts his hands on you and says you are under arrest, you deserve an attorney.
And Miranda says, let me just build on what Larry says. Miranda says that you have, once they read you your Miranda rights, or even before, let's say they don't tell you your Miranda rights, but you go to a police station, you say, I want a lawyer. They have to afford you the opportunity to call a lawyer. Okay, I truly believe Miranda, the intention and the language of Miranda says, once I ask for a lawyer, they have to at least afford me the right to get a lawyer. And in Illinois, our Illinois statute specifically says, remember, our statute came about before Miranda. So our statute has two sections in it that say you have a right to communicate with a family member, with a lawyer, with anyone you choose within a reasonable amount of time from the time you arrived in custody, right? Which another rule says that's within an hour. And then another statute says you have a right to communicate with a lawyer while you're in custody. That means in private, in confidence. So those rights are there in Illinois, separate and apart from Miranda. So we have codified, before Miranda came about, the great people of Illinois understood the power of police. They understood the abuse of power. They understood the coercive nature of being in the custody of police. And they made this law to say, when you're arrested, you don't give up your rights. The police don't get to say that they don't have to feed you, they don't have to clothe you, that they can hide you away, that they don't have to allow you to use the bathroom, they don't have to take care of your medical needs, and they have to give you phone calls so you can call your family and your friends and a lawyer. And if a lawyer comes, they have to let you consult with a lawyer. That's been the law in Illinois since the early 60s. But Miranda itself does say, only if you cannot afford a lawyer, one will be appointed for court. But if you request a lawyer and your family has a lawyer coming for you, right? They got to let them in the door. Well, they can't just say no.
If I could just add add one thought about that. I just want to distinguish between sort of the idea of Miranda and how it plays out, right? The idea of Miranda is that one is entitled to a lawyer when they're in custody. And I think that lots of people believe that's the case in police stations around the country, but in fact, it's not. And this intervention, this idea that we could have lawyers, in police stations kind of actually giving teeth to the idea of Miranda, I think is a really important one, because what it would do is shift that power imbalance where right now the onus is entirely on the person who's arrested, who is isolated from their community, from their family, their friends, their lawyer, to have the wherewithal to withstand police coercion and to ask for a lawyer. And unless that happens, it's not, you don't get a lawyer. And so that onus is so powerful, particularly in the face of coercive police custody. And if we could have counsel present, right, to just intervene there, it would shift the power from the police away from the police in a really important way. And I think that would actually give Miranda the meaning that it's intended to have.
Yeah, and Miranda really is limited. It's so limited because you have the right to a lawyer before the police question you during questioning. Miranda is a Fifth Amendment right, whereas we really need lawyers in police stations, yes, to prevent coercive questioning, yes, to prevent uncounseled waivers of rights, but also to do other things, Sixth Amendment rights to counsel, help people get diverted from the criminal justice system, prepare bail arguments, get people out on bail. That's not Miranda. Miranda only applies to questioning. That's why we need to expand it to the Sixth Amendment. That was the Escobedo case that actually came before Miranda, but Miranda overshadowed it. And even now, Miranda, the person has to specifically request a lawyer. It's got to be an unequivocal request. And even if the police disregard Miranda and they keep questioning the person, the law has evolved that, yeah, you can't use those statements in the case in chief, but you can impeach the person with those statements. And that's, that doesn't really, I think, provide the kind of right to counsel at a police station that we need. We need the Sixth Amendment to get into the police station.
That's really
I'd
helpful,
like to add a little
all of
something
you.
here too.
Oh, go ahead, Larry.
Just a little tidbit. We're focusing on police station, and we shouldn't, because as soon as Amy gets public defenders in every police station, police officers will begin to question their arrestee in the car before they get to the police station. So you have to focus on when he is arrested, wherever he has a right to a lawyer. In the car on the way to the police station, he has a right to the lawyer. Because if you wait till if it gets interpreted to be just in the police station, we'll lose again. When he gets arrested, he deserves a lawyer. Period.
That's a great point, Larry. You're absolutely right.
Yeah, and let me just say, it's in custody, right? When arrested, you're in custody.
That's right.
And that's why the language of the Illinois statute, which I think is a very good statute, albeit I'm trying to, change it a little bit because the police think that reasonable is 2 days. But so we will, but I have police officers. I have clients tell me that police officers, they put them in the squad car and the police officers hand them their phone. Right to the back seat. Here, you can call your mom.
Some of them do that.
Because you're in their custody. The police are supposed to give you the phone within a reasonable time of being in custody, in the alley, in the squad car, in your own home, but you're alone and you need to call your mom. That's the law. That's the law in Illinois. But they've never followed the law. Some police officers do. We have good reports about police officers actually, or let the client use their own phone. Everybody has a cell phone. But they'll say, no, they can't use their phone. They'll be calling a witness or, whatever, doing something bad on the phone. But the police can watch it. They can see what number you're calling. They can give you access to a phone. And they have to do that when you're in their custody.
That's right.
So do you think, given the sort of limited helpfulness of the federal constitution on this, should we be pushing for state level laws like Illinois, or do you think that we can sort of skip over that and just work politically to get agreements to allow lawyers to access people wherever they're arrested in police custody. What do you think, Randy? Do you think it requires law changes, or is it more of a political matter? But I also note that it's been the law in Illinois since the 60s, and not until there was political will did it actually become reality.
Yeah, no, that's a really good question, Rebecca, because I think it's really both. And probably I think I do agree, and I think this is what Pramal is saying. I agree that it's really a political thing that has to come from the grassroots. It's got to come from the community level. And communities need to see the value to the community of having the right to counsel attached. And I think that's where we are right now with this conversation, is when does the Sixth Amendment right to counsel, when should it attach? And what we're saying is, for the most value, for the biggest benefit to the community and to the people, the right to counsel should attach at the time the person is arrested. That's when they should have the right to the advice of a lawyer. And to get that affected and into operation, I think we have an opportunity here, but I think it's going to have to be a mass political movement that's going to do that. But people are going to, and I keep coming back to, people are going to have to see the value, and we have to start thinking about, how do we measure the value of having the right to counsel attached at the time of the arrest? Are there less incidents of police brutality? Are there fewer complaints about police misconduct, or those kinds of things? There's got to be ways, we've got to think about it. How are we going to measure the value? That seems to me the way that we need to.
I'm going to ask one more question, which is about enforcement, and it sort of speaks to some of the other questions that are on the Q&A. Some people are asking about police corruption, and also about the sort of arrangement, the on-call arrangement, which is more or less what Chicago has, and really what it looks like in most of Europe, where it exists, an on-call system, which requires the facilitation of the police to make the phone call, to make sure that that communication from within custody to the lawyer can happen. It requires the cooperation of police. And we have in this country, in a number of jurisdictions, police who are recalcitrant, who will not facilitate it. And that's what you're running into, I think, a lot in Chicago. So is there a model that we can imagine that either avoids the mediation of the police in that moment, or a model of enforcement that would sufficiently change how police are incentivized to act in that way? What are your wildest visions of what enforcement would look like, either structurally or in terms of, frankly, punishment or exclusion of evidence, or impact on criminal cases? What do you think the ideal model of really enforcing this looks like?
So I'll just start quickly. So if a police officer, if you can show willful violation of those laws I was talking about, that the commander of the district is willfully not giving phone calls, right? That he's told his detective, we see from pattern and practice that nobody gets a phone call in the 6th district of Chicago or something. And they don't have these posters posted, which is a law that they're supposed to be posted in every room where someone is sitting in your custody. And we found out by going around looking, they didn't have this. It's a class 3 felony for the commander or whoever's in charge of that police station. Now, how do I get the prosecutor to charge the commander of a police station with a class 3 official misconduct charge, right? So we have a law, we have enforcement, but to have the will of the prosecutor to actually charge someone in the Chicago police for not following the law, that's going to take, some doing. I think the other enforcement piece is you could change your laws, right? And then a little bit to make it, so that some sort of automatic, I don't know, the individual who wins their case by the evidence being thrown up, it's not bringing systemic change, right? I win that case for that client, I get the statement thrown out, or I get other unlawful evidence thrown out from an unlawful search warrant. That helps that client, but that has never brought systemic reform, because my public defender office has been doing that work for 100 years, and we win cases all the time, but it doesn't change the behavior of the police. It doesn't change making them follow the law and not violate people's rights in their homes or on the street or in the police station. So there has to be, we have a federal consent decree here in Chicago. How they're not making the police follow the reforms. Nobody's put the reforms forward. I mean, think about this picture. It's such a difficult question, Rebecca, because we have a consent decree. We have a new mayor who ran on a platform of police reform. We have laws on the books already where police are supposed to be held accountable. We have the Civilian Office of Police Oversight, which is supposed to be holding police accountable for not putting their body-worn cameras on when they arrest people or excessive force on the streets. And we see a little bit of reform, but I don't know if we can actually, it's such a difficult question. I just don't know if there's an answer because we have all this already and we're still not reforming.
We have to continue to push. And to your question, Amy, about what to do about a commander that doesn't put it up, and that's a Class 3 felony. Had you considered maybe convening the federal grand jury and taking it to the U.S. attorney? Because the Cook County is not going to prosecute a police commander. That's out of the question. Go to the U.S. attorney and have him prosecute him. I forget the actual statute, federal statute that would come into play, but I think there's a way to get him charged with that and look into it. That might be a possibility.
What about I mean, you talked a little bit about community efforts to really go after the FOP. I mean, I'm just thinking that all of the enforcement mechanisms rely on the power structure that depends on these violations. It's all sort of part and parcel of the same thing. Is there some way to think about this idea of linking the data that we're getting from attending police stations with movement actors to build it into political demands, basically, of activist movements? I don't know if Premal and Randy have any ideas about that or more technical solutions.
Yeah, I think that's a really good point. I think looking to the police as a source of, reform here is not going to be, it's just not going to be a fruitful way forward, I don't think, in terms of actually sort of making change. So I think figuring out ways to, as you said, track the data for political demands, I think is a huge part of this, right? Getting access to being able to see what's happening inside can feed political demands. Figuring out how behavior changes as a result. Are there less arrests? That sort of thing. Like that, for me, that's a huge piece of this. It could actually change the way that police are interacting with people on the street because they know that what comes later is different now. So being able to turn those pieces into bigger political demands for change that are, changes that are well beyond the sort of structures of the police department, because that's limited, right? We're not going to get very far if we focus there. I think we do have to focus on sort of on the bigger picture, and that those data points that we can get from increased transparency here and increased access, I think are very helpful to being able to support community demands for bigger change.
Yeah, I'm thinking about also some efforts in Philadelphia and some other cities to beef up a disclosure of police disciplinary records at arraignment, to defense at arraignment, to prosecutors refusing to use the testimony of dirty cops, frankly. And if that work can be expanded and this folded in, if you know the name of the officer who refused it, who was on duty that night, and you can track it to individual officers who can then be stigmatized, frankly, from effective participation in the system through a number of means is something that I think about. Randy?
Yeah, I think I totally agree with that we need, the Brady list, the list of prosecutors who have in the past engaged in misconduct or in the past have been dishonest in their police reports or when they testify in court. That needs to happen in every jurisdiction, in every DA's office, and it's not happening. It's one of the only ways that police officers are going to be held accountable. And I think police officer dishonesty is a major, major problem. And the only way you're even going to be able to start to deal with that is to make sure that they're held accountable for any time they've been dishonest in the past. Either DAs put them on a list where they don't call them as witnesses anymore and they become completely ineffective, or the information is given to accused people who can then use it to impeach the credibility of police officers. And I also don't want to, I want to think in terms of litigation. There's also these cases. Yes, Amy's right. We've been litigating motions to suppress and the exclusionary rule for many years, but I don't want to devalue the power of that there to transform the law. I've seen cases here in Massachusetts where we just had a major case about police profiling, where prior to this case, the law had been very, very difficult to show that police were engaging in profiling and engaging in stops of people on pretextual stops. But the case came and it was argued, and there were a number of amicus submissions, and the law changed. And now it's much easier to show that there's been a pretextual stop, and the law has been transformed. So that's another way through litigation. And I think another way to move the ball forward, and it's a long haul, is to see if mayors and county commissioners can form task forces that include community members, that include attorneys, that include law enforcement people, to look at these issues in a deeper way and make suggestions as how things can be reformed. And to follow through. And I think that, there is an opportunity there for that. We had in Massachusetts in 2018, we had major criminal justice reform. And one of the most important reforms that we had in Massachusetts was the establishment through legislation of a number of different task forces, like, for example, one on bail, one on restorative justice. There was another one on keeping track of data. And the importance of those task forces is that they were prospective looking. It wasn't like the legislature just passed the law and said, okay, that's it. No, they established these task forces that have to report back and they have to be reviewed. So they were looking at it prospectively. And I thought it gave a lot of power to the legislation. And it's something to think about when we're thinking about how to advocate for change in the United States, because we're dealing with thousands and thousands of communities and 50 states, and it's not easy.
Yeah,
I got a suggestion as to how proactively we might at least make an attempt to solve the problem. One was recommended by one of the legislators here in Chicago, in Illinois, and that is licensed police. We have licenses for everybody except police. If police were licensed, we would have a better way of dealing with them if they engage in a pattern of misconduct. Just take his license away and he's no longer a cop. The second thing is require police officers in Chicago and throughout the state to get their own liability insurance. Because the fact that Chicago backs them financially means they have no incentive to not continue to do the misdeeds that they're doing. If they had to get their own liability insurance, if the insurance company found out they were doing something they shouldn't have been and take away their insurance, they're out of business. They can't be cops anymore. And so I think those two might long-term at least put a dent in the problem.
Yeah, super interesting. So, I mean, basically what I'd like to leave you all with is the idea that we don't already know necessarily where all this can possibly lead, but what opening up police custody to outside intervention does is really expand the battlefield for us, and offers a lot of opportunities to shift and sort of assume power in communities, among people who are directly impacted, people who arrested themselves, and that the possibilities are really, really rich for change that we can't necessarily foresee in this moment, but will certainly be enriched and enhanced by opening up this space in society that is owned by us, but controlled completely by unaccountable police. And that's just a situation that cannot be allowed to continue. So I'd like to encourage everyone to read Fair Trial's brief on Station House Counsel. I just put it in the chat. Feel free to reach out to me, rebecca.schaefer@fairtrials.net, with questions. We are actively working on developing police station counsel programs in a number of cities. We want to know what you're working on in your city if you're a lawyer, what ideas you have, and really continue this conversation. So thank you so much for joining us, and thank you to all my panelists. You guys are amazing.
Thank you for inviting me.
Thank you, everyone.